Hi, I'm Greg Dell with Attorneys Dell and Schaefer, and today I want to talk to you about a case involving MetLife Disability Insurance Company and the medical condition of fibromyalgia and chronic fatigue syndrome. Now, in this particular case, which came out of the Northern District of Indiana Court on September 22nd, 2014, MetLife's denial of disability benefits was reversed by the court. What's most interesting about this case is that the policy had a neuromuscoskeletal limitation in the policy, which means that benefits would be limited to 12 months if you had a condition that you could not provide essentially objective evidence of. If I were to read to you what it specifically says, it states that if you're totally disabled due to a neuromuscular and soft tissue disorder, including but not limited to any disease or disorder of the spine or extremities and their surrounding soft tissue, then you will not get benefits for more than 12 months. So in this particular case, the woman was diagnosed with fibromyalgia, and MetLife initially said, well, that falls into the 12-month limitation, so we can't pay you for more than 12 months. However, on appeal, there was a specific note in the claim file where one of the upper-level claim unit directors or managers said that fibromyalgia was not subject to the neuromuscular limitation. So this is a very specific finding in this case, but this is what we consider as plaintiffs' attorneys to be a significant finding on behalf of claimants, because in the future, with this particular case, we are going to argue that if you have fibromyalgia or if you have chronic fatigue syndrome, which are the types of conditions where there really is no objective evidence outside of some types of, like an 18-point tender point test for fibromyalgia, then this type of language in this policy, or in this case, could really help you to win your case if you're limited by this type of language. So after approximately 3 years of litigation over this matter, the court found that MetLife abused their discretion by denying benefits to this former Verizon employee for, one, trying to argue initially that fibromyalgia was a 12-month limitation when in fact they said it wasn't, and also there was a Social Security disability benefit approval that came in down the road where MetLife did not give any reasonable basis for disagreeing with the Social Security finding. There's also a lot of discussion in this case, like there always is, where MetLife tries to say that fibromyalgia there's no objective evidence of disability, and when you have fibromyalgia, there is never any objective evidence of the disability. What you need to prove is how your symptoms and the pain you're having objectively disables you. So if you have a disability claim where you've been denied for fibromyalgia or any medical condition against MetLife or any of the major disability insurance companies, feel free to give us a call. We will review your denial letter, review your policy, and let you know immediately whether or not we can assist you.